For the New York action, the first cause of action that Baldoni alleges is as a claim for civil extortion. Now this is interesting because Baldoni's whole kind of theory hinges upon this idea that I was coerced and forced into doing things like giving production credits, making changes to the script, being forced to watch the opening in a basement, etc., because I was told that if I didn't do what you demanded, then I would be destroyed and crushed. Now, the Lively team has a document where there's about 17 points, or it rises to 17 pages, where Baldoni's signing off and acknowledging all the wrongdoing purportedly that he had done and the changes that he was going to allow to be made on the set. And Lively has used this to prove that there was sexual harassment taking place. Baldoni's position on that is that this was all part of a coerced nature. He was forced even into signing that document. He was coerced into it. In New York, it's important to say that there is no civil claim for extortion. You do not have a right as a civil plaintiff to come into court in New York and allege extortion. If there is extortion, you can proceed potentially with filing a criminal complaint. You could go to the district attorney's office and make your case, and if the district attorney decides to take a case, that would be a criminal case which they could pursue. In this instance, what we have is the plaintiff alleging extortion under California law, and that's how Baldoni tries to get around the limitations on civil extortion's non-existence in New York. To prove a claim for extortion under California law, the defendant, essentially in this case Lively, or Lively and Reynolds, must have threatened Baldoni to obtain money, property, or services. The defense must have known that the threat was wrong or unlawful, and the plaintiff must have given in to the threat of giving over or handing over money, property, or services as demanded. Now, what's interesting here is that we have a sense of how Baldoni could set forth an argument that would allow him to survive a motion to dismiss, because he's already seemingly made these claims that he had to provide stuff like production credits or making changes to the script based on threats. And since he gave in to this threat, one could argue that that alone could set him up for the potential to win on an extortion claim. Now again, he would still need to prove at trial that he actually was extorted, because we don't know what the truth is right now. However, the other interesting caveat here is that the plaintiffs are trying to use California law, and there's a catch-22 here. If the nexus is New York, and the choice of law generally when you bring a New York case is New York law, absent a contract that states that another state's laws will apply, the default then is to proceed with applying New York law. After all, New York judges are most familiar with New York law, and New York judges' whole position is that if you're going to seek a case or seek a resolution before our forum, the case should be adjudicated in conjunction or in accordance with our actual laws. It's interesting to note that in this instance, there's a catch-22. If you're the plaintiff, if I'm the defense, you're going to argue that California law absolutely should not apply, and for that reason, New York does not recognize a valid cause of action sounding extortion, therefore the claim for extortion must be dismissed. And that's a jurisdictional analysis that will have to be done, whether there's enough, just any justification really whatsoever to apply California law. Now, if you're the plaintiff, you may have a rebuke, or a rebuttal, I should say, concerning that argument, and ultimately what you would want to show is that there's enough connection to the state of California and New York to allow for this California statute or the California law to be able to be utilized in the New York court system. And that's a really fine line, and that's a hard tightrope to walk, because the second a judge is convinced that the California laws should apply in New York, it begs the question to say, well, why is this case not being heard in California? In which case, the plaintiff will have to make arguments that there's also enough ties to New York. Maybe the plaintiff's reputation was damaged more in New York. Maybe the plaintiff is residing in New York and has spent more time there and is suffering ridicule in New York, or financial harm more so in New York. But it's a tightrope that's going to be hard to walk. My ultimate estimate or guess is that this claim for extortion may very well be dismissed.